For the plaintiffs, Your Honor, Jeremy Fielding, Ben Barnes, and Grant Jones, Kirkland and Ellis.
Your Honor, it's Matt Stammel for the defendants.
Okay, let's proceed.
Thank you, Judge. This is our motion, so I guess that means we lead it off. I ordinarily would think it's kind of hokey to quote from use a famous Supreme Court quote at the beginning of an argument, but I think one is particularly apt here, and that's the old Justice Brandeis quote about how sunlight is the best disinfectant. And that principle is behind the simple but maddening reality of this case. Greg Allen, who is one of the defendants in this case and who runs Eland Energy, is our fiduciary, managing millions of dollars of the trust money in the form of its 50-50 investment in Eland. Several months ago, a whistleblower reported to us that Greg Allen was misusing company assets, including improperly withholding millions of dollars owed to the trust and using company money for his own personal purposes. Now, my client, Mr. Allen, approached Greg Allen, who denied the allegations, and my client made a simple request. He says, transparency. He said, get us the company books and records and backup materials. If what you're telling me is that there's nothing to see here, that these aren't the droids you're looking for, then just prove it, demonstrate that to us. And it's, of course, something we have an absolute right to, both as shareholders of the company and as principals of the fiduciary. And of course, again, if you have nothing to hide, then it's an easy way to put an end to the dispute. Unfortunately, Greg Allen refused to do that and kept refusing. So our client hired lawyers, us. We sent a letter and we demanded this kind of transparency and got more denials and more refusing. But in the middle of all that, Judge, sometime in late December, out of the clear blue sky, we get an email. Only after pressing and pushing, we get an email from our client, gets an email from Mr. Allen, Greg Allen, who tells him that they found 17 million of our dollars, as it were, under the company's seat cushions. And we said, well, that's striking, considering the fact that you denied that these things had existed. But we said, listen, if anything cries out for some Brandeisian disinfectant, it's now. Like, we need to know, where did this come from? And how do we, like this is $17 million. Again, they refused to provide us with any backup information. We ended up in front of you, Judge. You may recall we had a motion to expedite discovery. In that hearing, you pointed out maybe what we need here is an outside auditor to be appointed, which we said, praise the Lord, hallelujah, let's do it. We reach out and say, can we agree to an auditor that can come, presumably confirm what you're telling us, which is there's nothing to hide, move on. We were told no, they wouldn't give us an auditor that had the kind of power and authority to do the kind of work. So we settled on a backup plan, which was better than any of the alternatives. And that was, they would agree to give us their general ledger and related material, stand down while we reviewed it, and then end with a mediation. And the idea would be, they told us, listen, you'll find there's nothing there and we'll be able to work all this out in a mediation. Seemed like a great solution for us. We memorialized this in a Rule 11 agreement. And the touchstone of that Rule 11 agreement is transparency, because without it, we can't have a resolution. It's pointless to have a mediation if, once again, we're being met with, I promise these aren't the droids you're looking for, but I'm not actually going to show you the droids. You just have to trust me on it. So we go through this process, we get access, our experts show up to download the information from the servers, the general ledger, and we notice there's these things, and you see this in the briefing, these RVI files. Now, there's no burden associated with allowing us to download these RVI files, and what they really are, they're the backup information. So for instance, as I understand it, Mr. Barnes is here because he's more technically involved in this than I am, he can comment. But like, for instance, if there's a line item in the general ledger that shows, you know, here's a $1,000 expense that Mr. Allen incurred, right, in connection with it. This is like the backup. It's like what you'd click on and you'd see a copy of the invoice. Now, Judge, there's no burden to them allowing us to download this stuff. Like, all you have to do is just plug a cord in, download, and there it is. But they refused to give us information. And the reason they refused is because they said, we don't have to. And they hid behind this highly technical parsing of this Rule 11 agreement, where they say, look, the Rule 11 agreement says files, and this is not a file, and it's something different, and et cetera, all right? That leads us down to the present moment we're at right now. And I'm not going to judge with the kind of technicalities of the contract and the Rule 11, only because I think that the practical realities of our circumstance, I'm happy to stand on the briefing, which I'm sure you've read, but I just want to alert you to two practical realities of it. And those practical realities are, number one, this stay is going to end in 3 weeks. And if they don't give us this RVI data, the stay is going to be gone. All of these hyper-technical arguments they're making about what's a file and what's not go by the board. And we're going to be back in front of you one more time saying, Judge, we now have live litigation claims and they need to provide this information. And they're going to have to do it. So we're just trying to save time and money and energy by cutting to the chase and doing it now. Second practical reason, we're scheduled to mediate this case a week from now with Mr. Nolan. Ordering the production of these documents gives us a shot at actually making progress in that mediation. If we don't have this kind of transparency, again, without the disinfectant and the sunlight, there's no way this case is going to resolve. And so for all of those practical reasons, it makes no sense for them to hide behind this. And it kind of leads back to what I think is the most kind of frustrating thing. And it's what I started with. And I think it's really the bottom line here. There's only one thing that's going to resolve this dispute between the parties, and that is transparency. And the quicker Greg Allen and his lawyers realize this, the better and simpler and easier it's going to be for all of us. So our request to you, judges, order them to produce the documents that we've asked them to. I'm happy to get into a hyper-technical discussion if you think it would be productive. I have not gotten into it because I don't think it will be, and we're happy to stand on our briefing. And if for some reason, Judge, you decide that you don't want to order that now, then I promise you we're going to be back here one more time in 4 weeks saying, just let us plug into your machine and download this information from our company that we own 50% of and where there's no burden. So unless the court has any further questions or you want to ask about any specific contractual arguments that Mr. Stanwell makes in his response.
Not right now. Let me hear from Mr. Stanwell.
Okay, thank you, Your Honor.
Thank you, Your Honor. I have a PowerPoint I'd like to share in a moment, but I do want to start out with the point of, just this thought of, hey, why don't you just let them have the data? I think it's important to know that the MVI data that's at issue encompasses businesses and companies that the plaintiffs have no interest in at all. It's all mixed in, and you might recall that from before. So there's assets that are jointly owned between the defendants, my client, and Mr. Fielding's client, and then there's a lot of business that's not. It has nothing to do with the plaintiffs, and so it's not so simple as just downloading all the MVI data, because there's a tremendous amount of MVI data that is the plaintiffs have no right to at all under any reading at all. So there would be a tremendous amount of work to separate that out. So that's one issue. But Your Honor, I think when we get into, I know Mr. Fielding doesn't want to get into, won't even show you the contractual language. It's important to note that we're on a moving picture here that started with them seeking a receiver. They didn't just seek documents. They asked for somebody to come in and control our company. And then there was a lot of negotiation to get where we got to this, what Mr. Fielding calls a hyper-technical Rule 11. I don't really think it's hyper-technical. It's pretty straightforward, but it's the result of bargaining on both sides. And I think that's why the language is important. So I want to spend a little bit of time looking at the language today, if you'll allow me. May I share my screen, Your Honor?
Sure.
Yeah, thanks.
Oh, there you go. Oops.
All right.
Is it working?
Do you see my screen yet?
No, try again.
Okay, hold on. There we go. Let's see. How about now?
It should come up in a second. There you go.
All right. So I wanted to raise two issues because it appears in all the briefs that the plaintiffs file. And one for sure is that it continually accuses us of commingling funds. And Your Honor, it's worth talking about just for a moment because it's important to my client and it's important to us. We never confessed to commingling funds and we didn't commingle funds. And when Mr. Fielding talks about finding money in seat cushions, it's just not accurate. our clients run a business with robust accounting software. Every penny has always been accounted for. And then also in their motion, which they want to stand on, they talk a lot about the stripped maintenance files, and that's just simply not true. So there's language that they use that really tries to paint us in a negative light, and it's important to know that it's just not true. On this commingling issue, the Texas law is clear that commingling does not occur even if there's a mixing of dollars belonging to different persons if the number owned by each claimant is known. This is consistent throughout Texas law. They say, plaintiffs say that we've never provided an explanation about where this 16 million comes from, which is not true. It came with this email, which explained in detail exactly where the money came from. It's money, and this is an account that's been used since before the plaintiff's husband died in 2008. It's a historical practice where Eland would administer personal funds. It's fully accounted for in what's called a 1240 account. Your Honor, you're going to hear a lot about this if the case doesn't settle. But all the money to the penny has always been accounted for. So this is not, hey, we scrounged around our couch, we found $16 million, and we thought we'd send it over to Mr. Fielding's clients. It was always—
I'm sorry, Mr. Stanwell, you're real choppy. I don't know, maybe you can speak up for me because you're going in and out. I don't know if it's my computer or not.
Yeah, you are going in and out, Mr. Stamwell.
Apologize for that. Is that any better?
Keep talking, I'll let you know.
Okay. All right. Thank you. So there's been no commingling, Honor, and that's the purpose of this slide. And it's, we've accounted for the money. This is not finding money in couch cushions. We did not strip maintenance files. So this was featured prominently in their briefing. I don't think it has any impact on the merits here of the case today. But as soon as they raised the issue with us that they didn't get the maintenance files when they downloaded the general ledger information, the very next day we said, you can have those maintenance files. So that's just not an issue here. So there's really two issues raised by the motion. First one, does an agreement to produce trial balances and related general ledger detail entitle plaintiffs to millions of documents located in a separate software application and inaccessible via the general ledger? So that's the MDI data. It's in a separate software application and you can't even get to it with the general ledger. And number two is, does an agreement to produce supporting documentation for, quote, individual entries appearing within defendant's general ledger that equal or exceed $250,000, or for multiple entries reflecting a single common transaction that equal or exceed $250,000 in value when aggregated, entitle plaintiffs to supporting documents for unrelated individual entries because they were assigned a batch number. There were really two issues raised by plaintiff's motion. Mr. Fielding didn't really address the second one of dealing with the batches, but I'm going to go ahead and address it, Your Honor, unless you'd rather me not. But let's talk about this MDI data.
Let me just say this: we're pretty limited on time. You guys you have 30 minutes total for this hearing, and I have about 6 hearings starting at 3. And so, what the plaintiffs are asking for are 3 things found on page 13 and 14. And so, to the extent that you're talking about things that haven't been addressed, we don't have time for that. So let's get to what they are actually addressing, which is allowing the 2018 trust consultants to access the accounting database, work in good faith with the consultants to extract copies of the following specific records, and then provide all requested supplemental information not yet provided for the following general ledger entries pursuant to section 3D of that's what this is about. That's what you've asked for. That's all that this is about.
Perfect. And that's exactly what I'm talking about here, Your Honor. That's these 2 things then.
Okay.
All right, so I'm going to skip the background. I'm going to want to highlight this. When they came in February and requested emergency discovery.
Got it.
Okay, the first 2 are the ones that actually ended up in the Rule 11 agreement. The third one, fourth one, fifth one, sixth one did not.
Okay.
And this is why this is important. So I'll go ahead and go to the hearing on February 18th, where Mr. Barnes was explaining to the court that they wanted very narrow expedited discovery. And all they wanted was the court to order Eland to disclose its general ledger and the bank statements. And he said the general ledger simply represented a record system of Eland's financial data at the transactional level. So that's what he was arguing to you back then. That's why I said we're kind of in a moving picture here, Your Honor, because things get argued, we come to an agreement, and then they try to renegotiate through these hearings, Your Honor. We ask you to have them stick to their Rule 11. So here's the Rule 11. This is what we negotiated, and it's in the record. Documents to be produced. That's number 3A. Defendants will produce trial balances and all related general ledger details in bank statements and bank statement reconciliation documents.
So what does that mean exactly? All related general ledger details?
I'm going to get into that, Your Honor, in depth.
Okay.
So, but before we move off this slide, 3D talks about supplemental information requests. The trustees or the plaintiffs may request backup documentation related to individual entries appearing within the defendant's general ledger that equal or exceed $250,000 in value. So that's how the parties agreed they could request information beyond the general ledger detail. They could ask, but only if it's over $250,000. That's what was negotiated. They did not negotiate to get all of the backup. They only negotiated to get backup over $250,000, whether in a single entry or multiple entries in a single common transaction. So we already addressed this in our agreement. We addressed this in the Rule 11. Now they want all the backup, Your Honor. They want phone bills. They want rental car receipts. They want everything, what they're asking you. And not only for the Eland business, for all of Mr. Greg Allen's businesses. And that's why we're asking, Your Honor, pull them to their Rule 11 because they're just simply renegotiating. So I'll skip right to issue number 1. An agreement to produce trial balances and related general ledger detail does not extend to millions of other documents. So I've reproduced the language there, 3A. And it's important to note that the general ledger details modifies trial balances. And I'm going to go through that in detail because that's very important to this issue. The agreement to produce trial balances and all related general ledger details does not extend to these RVI libraries. Now, here's what I'd like to explain in case Your Honor has not dealt with it before. A trial balance is a periodic, monthly, or yearly summary of general ledger entries. That's from the Smith Declaration we submitted in response. So this is from an accountant who has testimony about what a trial balance is. It has 792 lines of data. So it's 792 lines of basically buckets of accounting information. And the general ledger is a record of the individual debit and credits. There are 45 million lines on the general ledger, and we've turned that all over to Mr. Fielding. Every single line entry, 45 million entries. When we were down here in February, this is what I was trying to keep from giving them, the 45 million lines. Your Honor said that you were thinking about having an auditor. And so if you're going to give an auditor, we agreed, okay, let's give them the general ledger detail, that backs up the trial balance. So you have the trial balance, which is monthly or yearly, and it aggregates what the general ledger entries are. So when you read the language trial balances and all related general ledger detail, it's the related general ledger detail modifies trial balance. You've got the trial balance and then the general ledger supporting it. So I'm going to show you on the next exactly what I mean. So this first box is an excerpt of our Exhibit Q, which is what a part of the trial balance looks like. Again, there's 792 total lines. Let me try to blow that up for you, Your Honor. But this is a good example right here. So if you look at the yellow box, this is again, the top box is a trial balance. Yellow box talks about general and administrative, and the travel and entertainment, you can see that column. And then for the second to farthest right column, M1 AMT, that's month 1, which is January amount. And then there's M1 BAL, which is month 1 balance. And there's a $20,000, $675.05. Well, if you go down below, Your Honor, and you look at the yellow boxes down below, this Exhibit G is the excerpt of the general ledger. Again, there's 45 million lines in the general ledger, but here's what the general ledger gives them. In the yellow box, you can see there's a vendor Rice Cameron, and there's a $97.30 general and administrative charge to travel and entertainment. And then right below it, you can see the vendor is Chuck Moretsky III, and he got some sort of payment for $431.49. And so those two numbers are part of what goes into the $20,675.05 travel entertainment trial balance. So you have the trial balances that aggregated by month and by year, and then you've got the general ledger detail that's the supporting documentation that rolls into the trial balance. And so what the parties agreed to is if they wanted information about the general ledger, again, this is what 3D does, then they would have to ask for more information, but only if it exceeded the $250,000 threshold. That's what we negotiated. So in the red box, Your Honor, Exhibit Q, the red box in that first slide talks about general and administrative. There was a legal settlement for $275,000. You can see that. And then if you go down into the actual general ledger, you see that $275,000 legal settlement referenced in the general ledger. And so what the parties did when they negotiated the Rule 11 agreement to put off the auditor hearing, to agree to mediation, they did all sorts of things. There was obviously consideration going back and forth, and that's why the parties entered into an agreement, is we agreed that if they wanted backup detail, if they wanted the RBI data, it had to be over $250,000. And so they would be entitled to it here because it's over $250,000 when you deal with this legal settlement, because that's a material transaction. But what the parties absolutely did not agree to is that they could get the RBI backup data for all of these inconsequential expenses. $150 to West Skipwith, $50 to the Natural Gas Society of East Texas, $67 to the Dallas County.
Okay, I can, that's Mr. Sting, I apologize. I just have at 3:00, we have a conference with
I understand.
another
And Your Honor,
judge, so.
I appreciate your patience with me as I go through this, but this is really important because they're asking for 45 million transactions, the backup for 45 million transactions, most of which.
I think I get the dispute. So Mr. Fielding, what is your response?
Very quickly, Your Honor, it's simple. You can probably see the same problem we're having here, which is didn't do anything wrong, weren't commingling funds, but I'm not going to show you how and why. Let me just address the commingling thing first. Mr. Stammel says, like, we've never admitted to commingling funds. And then I wrote down what he literally said. The reason why we can't give you these RBI entries, by the way, Judge, these are for Eland, the company. This is their books and records. I'm quoting from what Mr. Stammel says. The reason they can't give this is, quote, they involve, quote, a lot of businesses and companies that have nothing to do with Eland. This is why we've said they've admitted to commingling funds. They're admitting that the Eland books and records have access and involve the use of funds that have
Mr.
nothing
Fielding,
to do with
I guess what my concern is here is that there was a Rule 11 agreement that says as I understand it, it says the backup documents are only required in transactions of 250,000 or aggregate transactions of 250,000. And it does seem like you're kind of trying to renegotiate the deal here.
Here's what I would say, Your Honor. Let me address that when I come back to the RBIs. I think they're two separate issues. With respect to the question you just asked, the agreement says, and I'll read from it, quote, it's individual entries appearing within the general ledger that equal or exceed 250,000. I can make this easy, Judge. You asked about page 13. Every single one of the 40 listed there on page 14 and 13, or sorry, page, I guess it's 4 and 5 of our motion. Every single one of those 40 are an individual entry in individual general ledger entry. Now, within those, they have breakdowns along the lines of what you're seeing there, but each one is an individual entry. So we're not asking for anything, any of these that have more than 250,000. That's point number one. Point number two, if I can just finish, Mr. Stammel. Point number two is this RBI issue is different, Judge. This RBI issue has to do with, it's not the backup, it's the agreement says, and again, you pointed this out, it's when it's related to a general ledger detail. And for each one of these transactions, there's literally a link, this RBI link. It's a separate index, but it can be downloaded so that if I want to know, like, for instance, you see this in front, if I want to know, let's say on the travel and entertainment, I could click on that within the RBI. If I have the RBI database,
that's categorically not true. That's categorically not true.
Hey, Mr. Stammel, settle down.
I know, but it's hard when we're remote like this all the time. That's not true. I have a declaration.
Okay.
Independent.
You're not helping when you interrupt like that. So let me hear from Mr. Fielding.
Yeah, my understanding of this RVI index, and again, I'm happy to bring Mr. Barnes in because I know he's talked to our experts on this. It is a backup that contains the images. It's not something they need to turn over to us. It's not going to require any effort on their part other than letting us plug in and download those images. And it has to do, Judge, it's different than this issue about the backup information for each. This relates to their agreement to provide us with everything and all the entries and related general ledger detail. And again, Judge, it comes back to this kind of fundamental problem, which is what are they hiding here? Like, it's simple. There's no burden at all. All we have to do is let us do it. He admitted, and this makes me more nervous, not less, that it includes a lot of businesses and a lot of different things. And my concern, Judge, is hiding behind. First of all, I think it's very clear that it fits in the Rule 11, but we're wasting time because we're going to be back in front of you in 4 weeks on a motion to compel, and they're not going to be able to hide behind this technical application, which contorts this related general ledger detail beyond its intended meaning. So that's what I would say, Judge, is these RVI things are related general ledger details.
Based on what I've read, I'm going to go ahead and I don't think that the defendants have violated this particular Rule 11 agreement. I think that they've complied with it based on what I've heard. So I'm going to deny the motion. And can you go ahead, Mr. Stammel, and prepare me an order and inform me that I apologize. I don't have any more time to discuss this. I hope this doesn't hurt. I know how hard it is to get into Mr. Noland as a mediator. He's an excellent mediator. We're actually doing for all of you there who do commercial or tort litigation, we're actually doing a program together with Ken Rubenstein and a couple of the lawyers in June about remote mediation. Should be really interesting. So feel free to come to that with the business lit section and the tips section of the bar. But he's an excellent mediator. I hope it all works out. Get me an order and you guys are excused. Thank you so much.
Thank you, Judge. Appreciate it.
All right. We need to get first to the Krakow case. I think there's been a bit of a misunderstanding about what we're doing in the Krakow case today. I've been trying to set a status conference with you guys, and I think you guys, someone along the ways keeps canceling it, and there's a reason I've been wanting to meet with you. We don't have anything else set for today. I had told you that we had are both sides here, Galini and Farrell?
Yes,
Your Honor. Galini's here.
Your Honor, we did have a motion set today as our motion for discovery sanctions.
It was Judge Wheelis. That is not set for today. So that was a mistake, and it's not set for today. Judge Wheelis is on the phone. What I needed to speak with you guys about is we have a special setting coming up in your case. I thought we could get Judge Evans to preside for that, and he is not available. Unfortunately, that day he had told us he is available, and they're just very popular right now, the visiting judges. So I have Judge Wheelis on the phone right now. He's our regional judge, and he can tell us which judges are available at that time. Sorry, Judge Wheelis, that we're having to do this, but I don't want to have any, it's been hard enough to set this up. So I talked to you briefly about this before, Judge Wheelis, that at the end of June, and give me the exact date that you guys are specially set.
It was the 28th.
28th. We needed a judge to hear it. I thought Judge Evans was going to be able to hear it, but he had something come up. And I think you had mentioned that you could hear it, but I know that was a couple weeks ago and the hearings got canceled. I'm not sure if that was my fault or someone else's. So I have the attorneys here. And so I would love to be able to find out what judge we could get for them to hear this and get this resolved right now.
Well, June 28th is a Tuesday. Is it June 27th? Do y'all start on Monday or Tuesday?
We typically start on Tuesday, but if you guys wanted to start on Monday, you could.
Do y'all have a judge in mind? Are the parties agreeable to a certain judge?
I think, I mean, we're flexible on our side.
I think we are, Your Honor.
What kind of case is it? How long will it take to try?
I've told them they have up to a week to try it.
I don't think it's gonna take that long. It's a,
We'll both poke our eyes out by then, Your Honor.
yeah. I think, Kit, I think 3 days is,
Yeah, 2 to 3 maximum.
yeah, I think 3 with jury selection.
And it's a commercial litigation case, correct?
Well, it's a family trust dispute, breach of fiduciary duty and fraud.
Okay. So you would prefer to have a judge with
It's really hard
civil?
to say who's available. I just have to make some phone calls. Do y'all want to try the case so much so that you're not going to object to anyone that I assign?
Well,
Kit and I are both
I
lying.
would, for my
Haven't seen
sake,
the
I want to
list
have
yet.
somebody. I have a role in this too, I think, and my feeling is I want somebody with civil experience. I don't want to, no offense to Judge Lena Lavario, who's a great person, but I don't want her to hear this. I want somebody who has more civil. I just picked a name out of the hat, nothing against her, but I want
Now,
somebody
Your
with
Honor,
civil experience.
If Ms. Farrell is amenable to this, you've been involved in this case, and I entirely trust your judgment on somebody that could fill in for your shoes.
Yeah, I agree.
Well, Judge Wheelis, you had said you might be available, but are you still available or not?
I'm still available.
How do y'all feel about Judge Wheelis? I know you're a little awkward situation. He's right here, but I want to get this resolved.
Your Honor, not knowing him personally, I'm certainly fine with it.
Yeah, Your Honor, if you think that Judge Willis is capable of handling it, is good choice, then we're cool with that too.
Okay.
I'm board certified in civil trial law and personal injury trial law and criminal law. In Collin County, there are courts of general jurisdiction, so I tried it all. Before I became a judge, I was a civil litigator, mostly personal injury cases.
Okay, awesome.
Perfect. You're more qualified than I am, probably.
He outranks me, Your Honor.
Yeah, me too.
And this is going to be a jury trial, if I recall, correct?
Correct.
Okay.
Yes, Your Honor.
And then,
So it'll be June 28th.
did you guys want to start on the 20th? You have to finish by that Friday. So do you want to start on the 27th? Do you want to start on the 28th?
I like the 28th personally, but Barney, what's your feel?
I've gotten the clients all geared up to take off work from the 28th. I think that they'll freak out on me if I make them go forward today. So 28th is good, if that's okay.
I only have a court reporter until that Friday. So
That's
Judge Wheelis, you'll have to, she's available to that Friday. And then you have vacation the next week, right, Tony? Is that right, Tony?
I do.
Okay.
And
So-
actually, yeah, I do.
What were you saying, Tony?
I already have a sub lined up for the week of the 28th.
Okay. All right. So Judge Wheelis, and I'm totally flexible. You want to try this in my courtroom, or do you how do you usually do this?
Stick me wherever you want, Judge. That's your courtroom. If you want to use it, I'll go somewhere else.
No, I'm going to be out of town, so that's why I'm
Oh, you
using.
are? Okay,
Yeah.
then
So
I'll use your courtroom.
yeah, does that work okay for you guys?
Of course.
Yes, Your Honor.
Okay. Judge Wheelis, if you could just get us an order appointing yourself for that 4-day period, and I really appreciate you filling in for us.
Okay, glad to help out. Look forward to meeting everyone on the 28th.
And let me give you the cause. Do you need the cause number for this?
Yes, sir.
It's DC 193038.
DC 193
Zero
038.
30 Krakow versus Combs. All right, thank you so much, Judge Wheelis, and we'll go ahead and let you go. We'll let you go. Thank you so much.
Hey, Your Honor.
Yes.
We'd had a hearing set for today. The notice was filed on the 13th for our sanctions for discovery. Do you not? I
apologize that if that, I think something got lost in translation. I wanted this hearing so that you could talk to Judge Wheelis so that we
Yeah.
can work this out. I don't have time on my schedule today for anything else. I think somewhere along the way, someone may have given you permission. They did not have my permission. This was supposed to just be a status conference. So if you need to set something like that, I'm glad to hear it in the future. I just don't have time today.
Okay, we'll reset it.
Okay. And let me just, Tony, let's go on the record real quick. We're going on the record on DC 193038 Krakow versus Combs. Counsel, make your appearances.
Maureen,
John, go ahead.
sorry. Maureen Farrell for the plaintiffs.
John Galini for the defendants.
And the parties have agreed off the record, I believe, that previously you had agreed to Judge Evans to hear this trial specially set on June 28th due to his unavailability. Judge Ray Wheelis has agreed to step in, and I think you guys are not objecting to that. Is that correct?
That is correct.
Correct, Your Honor.
All right. Thank you so much. That's it. Thank you, guys.
Your Honor, just for the record as well, as counsel for defendant, I will at least let Ms. Farrell know that she did properly notice that. And if there was something lost in translation, I just wanted you to be aware.
Thank you, Kit.
I'm not trying to mess with anyone. That is not necessarily anyone's fault. It's just I've been trying to get this set up, this conference, because it's getting really hard to find a visiting judge because
No, we really appreciate it.
I agree. It's just like getting ready for a horse race and having the race canceled. But Your Honor, we appreciate it. Thank you so much.
I appreciate it. Thank you so much, guys.
Thanks.
Okay, so do we have everyone here? Mr. Garner, you're having serious problems with your Zoom, it seems like, but we have both sides here on State Farm Mutual's auto insurance versus Kelly. Both sides here.
Yes, Mr. Garner is here, and yes, Your Honor, I am having technical difficulties. I apologize.
That's all right. Other side here.
Lorenzo Brown here for Mrs. Kelly.
What is left of this case at this point?
We're the two lone survivors, Your Honor. I represent Jacinto, the defendant Jacinto, and she's the only remaining defendant. And then Miss Kelly's the only remaining plaintiff in the matter.
And is this basically at this point just a regular car wreck?
Yes, Your Honor.
Pretty much, Your Honor. Mr. Garner's office has informed me that they only have minimum limits of liability. My client has a lot of damages and Medicare, she's about 75 years old. So Medicare paid her bills. And so we have to sort through that to see how much, because any judgment would go to Medicare. And we may have to join in her underinsured claim.
Mr. Garner, have you guys settled with Mr. Brown's client?
Not yet, Your Honor. Like I said, he's the sole remaining plaintiff in the case. Just as a brief way of background, Your Honor, up until last Thursday, they had claimed closed about $5,000 in medical bills. And then late last week, Mr. Brown, on behalf of his client, filed some additional medical billing and records affidavits that we had not been disclosed and that we'd never seen before, which greatly increased his claim damages. I haven't seen it yet, but I'm informed that Mr. Brown filed a motion for continuance today of tomorrow's setting in order to resolve that problem, in addition to getting the other carrier, the UM carrier, involved. So that's kind of where the case sits right now.
What's your position?
The UM carrier.
Mr. Garner, what's your position?
Your Honor, frankly, this is an old case, and I would tend to not agree to the motion. But if there is, in fact, new medical, I'd like a chance to get an expert to look at that, determine if we need to controvert, et cetera. If that doesn't happen and it doesn't get pushed back, I'd have to take the position tomorrow that we exclude that evidence because it wasn't timely produced, and that probably works a disservice to the plaintiff. So I don't really, say that I would oppose the plaintiff's motion for continuance of tomorrow's setting based on the circumstances.
So this is, let me just tell everybody here this, because it's going to affect everybody. We're in the middle of trial right now. We're in a multi-week asbestos case. It's going to finish, I think, on Wednesday. That's what the attorneys are telling me. And so the reason I wanted to have a quick conference with everybody is just let them know I don't want you to come by tomorrow because I'm not going to make you waste your trip. But I do want to talk to you about the possibility of trying this or trying a case this week. I'm not opposed, if you guys aren't opposed, to moving this trial setting on this Jacinto case. But I don't. It sounds like we have kind of an agreement on that. How much time do you need to get this ready?
I would defer to Mr. Brown on that, since it sounds like he intends on adding a new party to the mix.
60 days, Your Honor.
Okay, it seems awfully optimistic. Mr. Garner, is that enough time for you or not?
There's plenty of time for me. I think I'm in, that would be more than sufficient for my purposes.
All right. Rhonda, we're going to reset this case to July 26th. Does that work for you guys?
Yes, Your Honor.
Yes, Your Honor.
All right, we'll reset you guys to July 26th. Good luck with everything, and we will see you on the next one.
Thank you, Your Honor.
Thank you, Your Honor.
Wagner Warner versus Garcia. Malcolm Renwick is the defense attorney. Forrest Mays, the plaintiff's lawyer.
Good afternoon, Your Honor.
So you kind of heard what our situation is. So how long is this going to take to try?
I'm thinking a day and a half, 2 days max.
Yeah, I wouldn't disagree with that. It's the plaintiff's show, and so whatever he thinks, I'll agree with.
What do we have in this case? Do we have a doctor testifying, or what is the situation?
I have a doctor by video and a chiropractor, and my client and 1 to 2 damage witnesses.
Yeah, what about you, Mr. Winwick?
I've just got my client.
What do y'all think? Do you guys want to try to go on Thursday? It's somewhat up in the air, but I'd say it's 70% likely that we'll be able to reach you on Thursday. Or what do y'all want to do? There's no great solution here. We're just kind of slammed right now.
Yeah, my only thought with 2 experts and 4 fact witnesses picking a jury, a day and a half, I think might be very optimistic in terms of trying to get it done, but I'll defer to plaintiff counsel on that. It's his case.
Well, I agree, and I think there are some issues with some objections that I've got to some of the designations for deposition and things that will need to be addressed by the court before we pick the jury. So I expect that very well could take an hour, and it may not, but there's some evidence that I know the defendants want to get in that I'm going to ask the court to exclude, and so there's going to be multiple issues that need to be addressed.
I mean,
I don't think that there's going to be an agreement on some of those issues.
I did have a special setting next week, but it looks like it's going to almost certainly go away. So I could try it on Thursday and carry you guys over to next Tuesday, or, I mean, there is no perfect solution. I mean, I'm just being honest with you. We could delay it, delaying it, you may not get reached the next time either. At least we have some idea and we're going to go.
I prefer not to have the jury have to wait over the weekend and then come back. I think that it'd be better if we could try it on, Tuesday, Wednesday situation. I know the court's.
I'll just tell you, Mr. Mays, I'll try. There's no guarantees. I mean, this is not an ideal situation, but at least there's some degree of certainty. But I'm also okay with moving it if you guys both want to move it. I just want to be completely upfront and say, hey, look, this.
Yeah.
I don't know what's going to happen in the next setting. I could set you for next week. I don't think you'd get reached. We have a pretty big case ahead of you. How does? Let me see if the next week is better, the 24th. You would be number 6. That's not good. Let me see.
I think I'm set in your court on another case, Judge, and I don't know what number I am on that, but I think that case is going to settle.
Okay. Is it? Let me see if I can find you on that day, on the 24th. Yeah, you guys are, that case is lower down. That's a 2020 case. Let me see about the next week, the 31st.
I've got a special setting on the 31st.
Okay.
Old case in the 101st.
Okay, I don't want to mess with that. Let's see, we just had a settlement on one of our special settings. Is it this one? Oh no, that's the that's the case I have to try to just, they keep setting hearing after hearing, they're pro se's and they keep setting hearing after hearing. So I need to get that one done. My June 14th special setting just went away. So that might work. Let me see. Yeah, June 14th is a good one.
Okay.
You'd be number, oh wait, no. Wait, I'm confused here. Oh, okay, I got that confused. Sorry. That's not going to work either. Let me see, June 21st. Yeah, you'd be number one on June 21st. How about that?
That sounds like a winner, Judge.
I think I can do that too, Judge.
Okay. All right, Rhonda, go ahead and reset their case to June 21st.
Got it.
All right, you guys are excused.
Thank you, Your Honor.
Have a good one.
State of Texas versus $20,900. Ms. Parker, are you there?
Yes, I am. Good afternoon, Your Honor. How are you?
Good. What's the status on this case?
So the status on this case is that on the answer that was filed by one of the defendants, it had no email or phone number. My investigator finally located a phone number for her daughter. This case has been ordered to mediate, so I've been trying to contact Ms. Sharp. I sent a letter, but we finally found a phone number that works. However, she doesn't have access to a computer. So I spoke with her regarding her ownership interest in the vehicle, because that's the only, she doesn't have any ownership interest as to the currency that was seized. Her son, Anthony Sharp, has ownership interest in the currency, but he is currently in TDCJ, and he is, I think his projected release date from what we saw online was June 26th. So she is—
Can we do a Zoom trial with him?
I think we could do a Zoom trial with him. I'm trying to get her out of the case, trying to see if I could settle with her regarding the vehicle. But I wanted to, I guess, speak with you first regarding this case, because I know we were set for tomorrow. And I believe she thought we were set in June, even though we're set for tomorrow. And then I think she was also going to speak with him regarding her possible authority to settle the case as well. So I'm trying to get it disposed of in that way, since they're both pro se and don't have an attorney.
So why don't we go to trial on Thursday on this? Can you arrange, do you have the ability, or I'm sure you have the ability, but do you, are you able to reach out to the TDC and see if we can get him available by Zoom so we can try this? And Rhonda can send you the link. Well, it's the same link as you had today. We're using the same link.
Yeah. So I do not know how to reach out to TDCJ, but I can see if my investigator does.
Well, I know my bailiff. I'm pretty sure my bailiff can. So if you can just get us all his information from DDC, we can usually just contact them ourselves and send them a letter from the court and everything. So if you can just get us that info, we'd be glad to do that.
Okay, and then I guess before we, if we set it up to go to trial on Thursday, I guess before we actually, I guess, commence the trial, then I guess I could have an opportunity to speak with him as well, because I know,
yeah, let's see.
I assume he has no that the trial is set for this week. We're just trying to figure it all out since they're both pro se defendants.
Yeah, and if you can get any information you have to Rhonda about the mom, that would be helpful too.
Okay, I'll give her the phone number that I have for her, because that's all I have for her. Again, she doesn't have an email address or anything like that.
Is your office in the courthouse, or do you have a separate office?
We're in the records building.
Records building. I may just, is it possible? So you said she doesn't have access to computer. Do you want to go ahead and have, however you want to do it? I'm happy if you want to come and do the trial in person and remote him in. or if you want to be, it's difficult to do it hybrid with attorneys there. I can do hybrid witnesses, like where the witness is remote, but it's hard to do it where the attorney is somewhere else, but the one's like one side's here and one side's not, if that makes sense.
So whatever works best. I'm gonna have to contact her, I guess, and see, and I'll give her number to Rhonda too, so Rhonda can contact her and see if she's available on Thursday to go.
Yeah.
And then
No, don't ask if she's available. She's going.
well, yes, that she's going. So what works? Should she come to our office? Should we come to the court?
If she doesn't have a computer that can access Zoom, then I think it'd be better for both of you to come to the courthouse.
Okay.
If she has a computer that can access Zoom. Now, if it turns out we can't get this, the prisoner, his information, and if they're not going to cooperate with us, then we're going to have to move the trial setting. But if they'll let him testify if they have a Zoom connection or a phone connection or whatever, I'd like to get it done one way or the other if we can. But if we can't, we can't. When did you say he's getting out?
His projected release date was 6/28/2026.
No, we can't wait that long.
Yeah, so no, we can't wait that long. But I didn't know if his mother had power of attorney, so I was also trying to speak with her regarding that in regards to trying to maybe settle this matter.
Okay. We'll tell them we're called down for Thursday, get the information to Rhonda as soon as possible, and then let's have a conference with Gary tomorrow, Rhonda. Try to get her to get the information to Rhonda this afternoon, and then we'll have a conference with my bailiff and see if we can't get something.
Okay, I'll send Rhonda the phone number. And then what time are we set for then on Thursday?
9 o'clock.
Okay.
Maybe remote, maybe in person. We'll just figure out what depends on the defendant. And if they want to try to settle it, if you guys settle it before then somehow, just let us know.
Will do.
Okay. Thank you, Ms. Parker.
Thank you, Your Honor.
You have a good
nice
day.
Bye.
So Judge, you're thinking they're gonna have a quick deliberation?
What do you mean? Oh, I don't know.
What's the line?
Who knows? I don't know who this new person is that just showed up. That's our last hearing, I think, isn't it? Yeah, because the Jackson hearing is canceled. So call me, Rhonda, if there's anything that you need. And